Imagine this. You're at your friend's place, just trying to wash your hands like a civilized human. You twist the faucet, and boom. The handle explodes like it's auditioning for an action movie, and suddenly, your hand's starring in a medical drama. Later, you find out your friend knew it was cracked, but said nothing. So now you're wondering, is this friendship or a lawsuit waiting to happen? This is the case, where broken plumbing met broken trust, and the court decided who's really liable when hospitality turns hazardous. Welcome back to 99 Rights, online, where legal rules get real. Today, we're diving into a California case that flipped the script on duty of care. Rowland vs. Christian. At the heart of this courtroom shakeup is one big question. How do courts decide who owes what to whom? Spoiler, it's not just about broken sinks, it's about breaking legal norms. Let's unpack the case that redefined responsibility. James Rowland, the plaintiff, was a social guest in Nancy Christian's apartment. He asked to use the bathroom. While turning off the cold water faucet, the porcelain handle broke in his hand, causing severe injuries, including severed tendons and medial nerve damage. Christian had known for 2 weeks that the faucet handle was cracked. She had reported it to the building manager, but it hadn't been fixed. She didn't warn Rowland about the defect. Rowland sued for negligence. The trial court granted summary judgment for Christian, arguing that as a social guest, Rowland was a licensee, and Christian owed him no duty to inspect or repair. Rowland had used the bathroom on a prior visit. The crack in the handle wasn't obvious to a casual observer. Christian admitted knowing about the defect and reporting it. She didn't warn Rowland, despite knowing he would use the faucet. The court emphasized that a person's life or limb doesn't become less worthy of protection based on their legal status. Whether someone is a guest, customer, or even a trespasser, the question is, did the landowner act reasonably under the circumstances? The court basically said, look, your limbs don't come with a legal discount. Whether you're a guest sipping wine, a customer buying soap, or a trespasser doing parkour through someone's living room, your body still deserves basic protection. The real question isn't who you are, it's how sketchy the landowner's behavior was. So if the faucet explodes or the floor collapses, the court's asking, did the host act reasonably, or were they running a DIY trap house? For law students, Rowland vs. Christian is the Beyoncé moment of tort law, a doctrinal glow-up that ditched dusty categories and embraced the fabulous trio, foreseeability, risk, and reasonableness. It's the case that said, let's stop labeling people like they're at a dinner party and start asking if someone was actually being careless. For everyday folks, it's a wake-up call. If your faucet's a ticking time bomb, or your floorboards moonlight as ankle traps, you might be liable, whether it's your bestie, your barista, or a burglar who gets hurt. Moral of the story, fix your stuff, or risk starring in your own courtroom drama. The decision reflects a broader legal trend, moving away from rigid rules toward flexible, fact-based standards. It aligns tort law with evolving social norms and expectations of care. This decision is tort law's version of new phone, who dis? It ditched the crusty old rulebook and said, let's be real, life's messy, and so is liability. Instead of obsessing over labels like invitee or licensee, like it's a legal dating app, the court went full modern. What's reasonable? What's fair? And what would a normal person do without a law degree and a magnifying glass? For more case briefs and creative law study tools, subscribe to 99 Rights online. Let's make the law make sense together.